Hey there, I'm Ivy Tellez. I work at the Summit County Attorney's Office, and I've been there for about 5 years. I work with some of the best people. Today I've been asked to present on Rule 404B, which you all know or should know is one of the most litigated evidentiary rules. And we could probably talk about it for days, but I've been given 15 minutes. So I'm going to focus on what some consider it to be the biggest problem with 404B. So let's review what the rule says. Evidence of a crime, wrong, or other act is not admissible to prove a person's character in order to show that on a particular occasion the person acted in conformity with the character. So in other words, or put another way, the rule prohibits evidence that a person engaged in prior bad behavior to show that he or she engaged in bad behavior again in the case at hand. Of course, subsection 2 provides admissibility of this type of evidence for several non-character purposes, such as those you see listed in the slide. Additionally, case law provides other non-character purposes for admitting crimes, wrongs, or other acts. For example, in Garcia, the court allowed gang affiliation to prove action in concert with each other. In Whitebeck, the evidence from a prior burglary was allowed to connect the defendant to the charged defense. In von Niederhausen, the prior sexual touching of victim to prove absence of mistake and intent to cause affront or alarm was allowed. And in Barney, other violent acts against victim to explain why she did not flee or report sooner was allowed. However, the rule is not as straightforward as it seems. Courts and litigants alike are confused about how the rule should be applied and how it should operate. The analysis of the issue in appellate opinions is often incomplete, inconsistent with other opinions, manifestly incorrect, or lacking altogether. The nearly identical federal rule has generated more reported decisions than any other provision of the federal rules. And there's little difference in state courts. In many jurisdictions, the admissibility of uncharged misconduct evidence is not only the most frequently litigated issue on appeal, but also the most common grounds for reversal. Well, what about Utah? Utah's history with Rule 404B has kind of been on its own roller coaster. Back in 1982, when Utah adopted Rule 55, which was a predecessor to Rule 404B, the Supreme Court, the Utah Supreme Court held in Forsyth that it was an inclusionary rule. But then it turned around in 1988 and ruled that in Shickles that it was an exclusionary rule. And then in 2017, the court in Thornton decided that it was an inclusionary rule again. So the takeaway here is that relying primarily on Rule 404B carries an inherent risk. You might get the evidence in, you might not. You might get overturned on appeal, or you might not. So what do some consider to be the biggest problem with Rule 404B? It's that we run to it too often. That's why we have so much case law with similar underlying facts, yet different outcomes on how to apply the rule. But by always running to Rule 404B, we are ignoring another avenue for the introduction of other acts evidence. So there is another option. There's a preliminary question we should be asking ourselves before we turn automatically to Rule 404B. It should be obvious, but sometimes it's not. We should be asking ourselves first if the evidence we want to admit is intrinsic or extrinsic to the crime charged. So in 2009, the 10th Circuit in Parker found that Rule 404B limits evidence of other crimes, wrongs, or acts, not the crime in question. The court reminds us in that ruling that Rule 404B does not apply to evidence that is intrinsic to the crime charged. Generally speaking, intrinsic evidence is directly connected to the factual circumstances of the crime charged and provides contextual or background information to the jury. Extrinsic evidence, on the other hand, is extraneous and is not intimately connected or blended with the factual circumstances of the charged offense. Additionally, a 1991 advisory committee note to the federal rule specifically states that the rule does not extend to evidence of acts which are intrinsic to the charged offense. So should this apply to Utah's nearly identical Rule 404B? Now, unfortunately, Utah case law is underdeveloped with regards to intrinsic evidence. Utah appellate courts first engaged in meaningful analysis of this issue in State v. Burke. In Burke, the court noted that under under the federal rules of evidence, 404B does not apply where the challenged evidence is inextricably intertwined, those are the words they used, with evidence of the crime charged. In Burke, the court noted that but despite noting that Utah's rule is almost identical or is verbatim to the federal rule, the court in Burke did not ultimately decide whether the same distinction applies to the Utah rule until Lucero. In Lucero, the Supreme Court stated, since Rule 404B applies only to evidence that is extrinsic to the crime charged, this would preclude applicability of the rule altogether. This is because the evidence would be considered part of the case narrative and has important probative value that bears directly on the crime charged. While Burke and Lucero demonstrate that Utah's Rule 404B is not applicable to intrinsic evidence, the fact remains that there is little Utah case law on this legal principle, which demonstrates that it is little understood and generally overlooked. A better understanding of this principle can and should be gained by looking at examples from other state and federal courts. Now, because inextricably intertwined language in Burke is far too narrow, it should be noted that there are other categories of intrinsic evidence that are not subject to Rule 404B. This includes evidence that is not inextricably intertwined, proof of involvement in the charged crime, same criminal episode, necessary preliminary steps to the charged crime, background to the charged crime, and context, as well as any evidence that proves relation between co-defendants. So under inextricably intertwined, this would be evidence of crimes that are so linked with the crime charged in point of time and circumstances that one cannot be shown without proving the other. In Warren, the defendant was charged with murder. At trial, the court allowed the prosecution to introduce evidence that the defendant stabbed a second victim immediately after stabbing the first one, even though the defendant was not charged with the second stabbing. The defendant appealed, arguing that the admission of the second stabbing violated Rule 404B. But the Ninth Circuit Court of Appeals held that the rule did not apply because the evidence of the second stabbing was inextricably intertwined with the evidence of the murder charged. In Kupfer, similarly, the court allowed proceeds of one uncharged conspiracy that were used to pay for the defendant's involvement in the charged crime. With regards to proof of defendant's involvement in the charged crime, courts consider evidence of uncharged misconduct to be intrinsic if it specifically ties the defendant to the charged offense. For example, in Parker, the defendant was charged with conspiracy for a scheme involving false representations in the sale of small aircraft engines. The evidence of the fraudulent sales that were not charged were admissible to prove the conspiracy that was charged. And similarly, in State v. Harris, which was a West Virginia case, the West Virginia Supreme Court allowed evidence of uncharged sex abuse as admissible to refute defendant's claim that he was not present for the charged offenses. With similar criminal episodes, under this category, courts hold that evidence of uncharged misconduct is intrinsic to the crime if it is part of the same criminal episode. This category encompasses misconduct that took place contemporaneously with the charged crime or was part of the same transactions as the charged crime. For example, in Daring, the defendant was charged with interstate transportation of stolen motor vehicles. At trial, the prosecution presented evidence that the defendant had murdered the owner of one of the vehicles in another state and tried to dispose of the vehicle because it was hot. The Eighth Circuit Court of Appeals held that the evidence was admissible and was not governed by Rule 404B because the murder of the owner vehicle and the theft and attempt to dispose of it afterwards were part of a single criminal transaction and occurred together with the charged crime over a 4-day period. Similarly, in Cancelier, the 11th Circuit allowed uncharged bank fraud as admissible in a trial for a separate bank fraud because all conduct occurred during the same period. Under this category, evidence of uncharged misconduct is intrinsic and exempt from Rule 404 when the evidence was a prelude or was part of the decision-making process that led to the charged crime. For example, in U.S. v. Lambert, the 10th Circuit allowed discussion that the defendant had with a co-defendant about robbing a man in a grocery store as admissible in the trial for the actual bank robbery that both men did. In U.S. v. Torres, the Fifth Circuit allowed evidence about uncharged sales of small amounts of cocaine admissible in trial for the sale of a larger amount of cocaine. With regards to background, courts have found that evidence is intrinsic and not subject to Rule 404B when the evidence constitutes background information directly connected to the factual circumstances of the charged crime. In Irving, the defendant was charged with both possession of crack cocaine and with intent to distribute and with witness tampering for seeking the death of a police lieutenant. The court in this case allowed evidence of prior drug investigation that lieutenant did to show why the defendant would want to seek out to kill him. In Weeks, evidence of a stolen car investigation was allowed into the trial for an assault on an officer because the officer was investigating that stolen vehicle. Context. With regards to this category, uncharged misconduct evidence is intrinsic and not subject, again, to Rule 404B when it explains the context of the crime to the jury. Without the admission of this evidence, the prosecution would be unable to present a coherent and comprehensive story regarding the commission of the crime to the jury. In McKinley, another West Virginia case, the defendant was charged with the murder of his girlfriend, who was the mother of his child. In this case, the court allowed evidence of 2 prior domestic violence incidences that were not charged, and in that stated, although the 2 domestic violence incidents in this case were not a single criminal episode, we believe this evidence was necessary to place the victim's death in context with her relationship with Mr. McKinley and to complete the story of the violence Mr. McKinley inflicted on her. Similarly, in Hall, evidence was allowed by the 10th Circuit on a prior drug transaction to prove the transaction that was actually charged. Next, with relationship between co-defendants, courts have found that evidence is intrinsic when it is used to explain relationships between those who have committed crimes with each other. This category of intrinsic evidence plays a particularly compelling role in conspiracy and racketeering prosecutions because it is essential that the prosecution be permitted to inform the jury of the background, existence, and structure of the enterprise by showing uncharged misconduct committed by co-defendants. A good example of this is in Kraut, where multiple co-defendants who were members of the Texas Mexican Mafia were charged with racketeering offenses. The co-defendants argued on appeal that the admission of the evidence about several uncharged murders and an uncharged attempted murder violated Rule 404B because it was offered to prove his bad character. The Fifth Circuit, however, Court of Appeals disagreed and held that the evidence of the murders and attempted murder was not introduced as character evidence, but as acts committed in furtherance of the racketeering offenses. Similarly, in Gibbs, the court allowed evidence of crimes that took place before the charged conspiracy to show the relationship between the conspirators. Now, in short, there's a wide variety of evidence that can properly be classified as intrinsic evidence that's not subject to Rule 404B. Prosecutors should consider each of these categories discussed as a potential basis for admitting other acts evidence at trial before looking to 404B. Now let's talk about the procedure for admitting intrinsic evidence. Because Rule 404B does not apply to intrinsic evidence, prosecutors are not technically bound to the rule's notice requirements. However, giving notice to the defense is best practice. Therefore, prosecutors should file a pretrial notice of intent when they seek to introduce intrinsic evidence. This notice should include a brief synopsis of the evidence of uncharged misconduct and that the prosecution intends on relying on the intrinsic evidence doctrine for admissibility. Those who fail to alert the defense and the court that they are seeking to introduce this evidence run the risk of getting an adverse ruling when the issue arises mid-trial and the judge is forced to make a decision without adequate time or preparation. Not to mention that raising the issue mid-trial can be disruptive to the proceedings. Next, if the defense intends to object to the introduction of the evidence described in your notice, then it should file a motion in limine indicating that it objects. This motion by the defense should contain more than just a cursory objection and should provide argument and case law supporting their objection. Pretrial evidentiary hearing may be necessary in some cases. And if the issue is raised and examined in this manner, the judge will be able to make a better decision. Remember that Utah case law in this area is underdeveloped, and it's better for you to educate your judge on this issue rather than spring it on them mid-trial. Next, the judge should then begin by determining whether the evidence is intrinsic or extrinsic to the crime charged. And if he or she finds that it is intrinsic, the judge still needs to perform a 403 analysis to determine whether the evidence is admissible. If the judge admits the evidence, then he or she should provide a limiting instruction forbidding the jury from convicting the defendant based purely on the defendant's character. The instruction should also explain why the jury is allowed to hear references of the uncharged misconduct. Now, prosecutors and courts should recognize that intrinsic evidence is necessary for jurors to have a complete understanding of the case that they are asked to hear, so that they can decide that case fairly. As the U.S. Supreme Court says in Old Chief, people who hear a story interrupted by gaps of abstraction may be puzzled at the missing chapters, and jurors asked to rest a momentous decision on the story's truth can feel put upon at being asked to take responsibility, knowing that more could be said than they have heard. A convincing tale can be told with economy, but when economy becomes a break in the natural sequence of narrative evidence, an assurance that the missing link is really there is never more than second best. Admitting evidence under this doctrine can be a powerful prosecutorial weapon. Thus, it is imperative that we use it appropriately. Now, if you want to learn more about this doctrine, please go and read Blake Hill's article in the BYU Journal of Public Law, which was published last February. I've included the link, and it's been provided in the conference materials if you want to read it for yourselves. And I want to conclude by sharing some of the wisdom in Blake's article, where he states, prosecutors have a heavy burden in establishing a defendant's guilt, and they should endeavor to present the jury with a complete evidentiary story. This effort should include advocating all avenues of admissibility for evidence, including the intrinsic evidence doctrine. The time for neglecting this doctrine has passed. Cases like Gabriel Fernandez's and so many others like it are the reason juries need to hear the full story behind the one act of violence that was charged. Let's stop automatically running to Rule 404B and start utilizing the intrinsic evidence doctrine to tell that story. What you do matters, and how you do it matters. So thank you for your time. Thank you for listening. And I've enjoyed talking to this camera.
I'm Blair Wardle from the Box Elder County Attorney's Office, and I recognize the difficult burden of taking long established rules of evidence and boiling them down to 15 minutes. So good job to Ivy for rules that have been argued and litigated for decades. And I've had the task of doing the same for Rule 609. And if Rule 404B is the most litigated, as Ivy taught us, then Rule 609 is probably the most criticized rule of all the rules of evidence. Scholars have been calling for its reform or abolition for decades. It's a hot topic of scholarly debate. My goal for you today, obviously, this is a riff on the For Dummies, like Gardening for Dummies type books. I know that my fellow prosecutors are absolutely no dummies. Some of the smartest people I know are prosecutors, so I was not going to put that in there. So this is Rule 609 for prosecutors, and my goal is to simply maybe do a little refresher course, maybe share a thought or two, something you may not have realized or known before, and provide some materials that'll be an easy resource to go to for the toolbox in the future if you have these issues. Simply put, Rule 609 applies to convictions, bringing in evidence of convictions at trial. And there are two types of convictions that are going to qualify or two types of classifications that will qualify to bring in. First is felonies. The other one is crimes of dishonest acts or false statements. Under the common law, prior criminal conviction would preclude somebody from even testifying at in trial. And the history of Rule 609 is interesting. As they were debating how to formulate this, it was hotly debated, and the people who were against it said that the use of prior convictions tends to deter defendants from testifying and to create unfair prejudice when they do. The opponents of it said that defendants' any past demonstrated willingness to engage in conduct in disregard of accepted legal norms is highly probative of their credibility, and that they shouldn't be able to be presented as an unblemished citizen. So they went back and forth on it, and the rule we have is based on the federal rule, which was a compromise between those two competing lines. So what constitutes a conviction? Well, it depends. If you have a trial, it's not until after there's been that finding of guilt, there's been a sentencing, and the appeal time has passed. If a person enters a guilty plea, then that conviction is fair game as soon as they are sentenced. All right, so those two classifications, I'll start with the felony ones. Felony convictions against a defendant, they have to be admitted. The rule says that they must be admitted if it passes the balancing test. And that burden is going to be on us as prosecutors. If the defendant is going to take the stand, right, suppose even if they're not, it's going to be, the burden is going to be on us to bring up that prior conviction and to show why the balancing test is met. And we'll compare that balancing test in a minute to another balancing test. There are 5 factors that must be established. I didn't list them here for brevity, and I've provided the link for if this issue comes up. But quickly put, the factors are that they're needed to prove or show credibility. The conviction is needed to show credibility, that it's not too old. They're similar, or the similarity, if it's too close to the charged crime, that could be a problem. That's too prejudicial. If the case only has testimony that's available and there's no other physical evidence, and then what's at dispute? Are the facts in dispute, or is the mental state in dispute? And if the mental state, the intentionality of the crime is in dispute, then the credibility might matter more, and the facts can be proven a different way. So those are the 5 factors that we'll need to worry about if we intend to admit a prior conviction for a defendant. If a person is if you're just going to mention that the person's been convicted of a felony, then those factors won't matter as much. But if you're going to try to get into what type of crime that was, then you're going to need to, you want to talk about the type, the timing, anything like that, then you do need to make sure those factors are established. Felony convictions against witnesses, really the only 2 things you have to worry about is the satisfying the rule and who has the burden there. Now, for witnesses, you just have to have your 403 balancing test, and the burden is going to be on the opponent to show why it should be kept out. So there's a little bit of your differences between a defendant versus a witness. If it's the defendant, as a prosecutor, you're going to have to show why you need it in. If it's for a witness, the defense is going to show why it should be kept out. The balancing tests are a little bit differently. In 403, it requires that the unfair prejudice be substantially outweighed, whereas in the 609, we don't have to have that substantially. It's just outweighed, period. With 403, you almost focus on the prejudice side of the scale to meet the burden, assuming that it's almost probative, and then you say, well, but does the prejudice outweigh the probative value? Here, you start with the idea that it's prejudicial, and then say, well, is there enough probative value to then outweigh that? So a little bit different balancing test there. The other type of conviction is a crimen falsi. I, unlike John as well, did not take Latin. But these are crimes that are characterized as involving some sort of dishonesty or deceit. And for these type of convictions, the court has no discretion. These come in regardless. Now, where you may have an issue is whether an offense actually classifies as a crimen falsi type offense. That may be where the court has some discretion. But if that's not at issue, then the court must allow it in. And in State v. Larson, we learned that these are the type of offenses that involve an element of deceit, untruthfulness, or falsification. The case also mentions that an attempt to do something also classifies as, it doesn't change it from being a crimen falsi claim. There was a case where they tried to argue that an attempted forgery was different somehow than a forgery, and that it did involve the intent for deceit. And the court said no. If you have an attempt, you have the same mental state as you would for the crime. So attempt crimes doesn't matter. So what details, real quick before we move on to that, as far as the crime and falsity offenses go, I did a search through Utah case law and found cases where they specifically said where something was or was not admissible under 609. And these are in the outline notes that will be available in the toolbox, but Utah has specifically held that the following are not admissible under 609. Theft, retail theft, burglary, and robbery. Utah has specifically held that the following crimes are admissible: theft by deception, securities fraud, forgery, tampering with evidence, providing false information to a police officer. And interestingly, in other jurisdictions, they interpret this much more broadly. I even found a case where possession of controlled substance was considered a crime and falsity offense, and they justified it by saying that it indicates a disposition to place the advancement of individual self-interest ahead of principle or the interest of society, and such proof might suggest a willingness to do so again on the witness stand. In other words, they have such a bad drug habit, they're going to lie about it. Utah has not ruled on that, though. And it seems strange, quite frankly. So what details can be disclosed? Well, we need to limit it to the nature of the crime, the date of the conviction, and the punishment, if necessary. And really, if you don't need any of those, then limit that. If you only care to let the jury know that the person is a felon, then that's the simplest, easiest way. But if the nature, the date, or the punishment matters, then get into it. But be careful, because a prosecutor may not parade the details of the prior crime in front of the jury. The defendant is subject to cross-examination only to test his veracity and credibility, and thus collateral matters should properly be limited to an effort to discredit him as a witness and not merely to prejudice the jury against the defendant. Care must be taken to ensure the defendant is not convicted for past rather than present crimes. And State v. Tucker is probably one of the seminal cases on this to help understand the context of what can be discussed. Time limitations as far as convictions, the default is 10 years. There's some arguments as to whether being on probation or parole would extend that time. I'm a little bit skeptical that it would, but there are some academic articles and cases where that is discussed. We can use convictions greater than 10 years, more than 10 years, but it's a little bit more sketchy. You do have to provide reasonable written notice and justify it a little bit more. Although there is kind of a line of thought that for the crime and falsity claims, that the 10-year requirement isn't as important as the felony one. When it comes to other types of convictions, pardon is never admissible. Juvenile court, it is admissible, but there are 4 requirements that are contained in the rule itself. For a 402 reduction, it is admissible if you otherwise meet the balancing test, or if it's still a felony. Just make sure that you're still meeting 609 requirements. And then the fact that a case has been appealed still means that it's admissible under 609. Now, the defense may be able to bring up the fact that it's on appeal or that it was appealed, but it is still admissible for context of a conviction. How do you get it in? Well, it depends on what you're dealing with the witness you're getting it in through. If the witness is going to admit that they had that they've committed the crime and they were convicted, then you just need to have them admit that they committed the crime and that it's within the 10 years. However, if they deny it, then you'll need to make sure you have a certified copy of the conviction, which you can get from any of your court clerks, or you need to bring in somebody to testify as to that fact. But we're not allowed to, under 609, to bring up the fact that they were arrested for something or that they were charged with something. That doesn't open the door. Okay, removing the sting. This is the idea that the defense knows that it's coming, so they're going to preemptively bring up the conviction. The court has said that is not ineffective assistance of counsel, so don't let anybody fool you on that. That is a valid trial strategy. However, this does not open the door to more extensive cross-examination. In other words, if the defense only brings up the fact that they've had a felony, that doesn't per se give you the opportunity to then start talking about the details and the circumstances and everything about that. You may just be limited to addressing that it's a felony, depending on if you can meet the rule. The other similar thing is opening the door. If this defendant tries to minimize a conviction or excuse a conviction, that's going to let you bring up some of the details of the conviction. Maybe you just started out with just talking about that it was a felony, but they start talking about how it wasn't that big of a deal, the whole thing was overblown. The court has said that that does open the door, and it will give you an opportunity to discuss a little bit more in detail about that. Even if you have a pretrial ruling that says that you cannot bring up the conviction, if the defense accidentally opens the door or decides to remove the sting for some reason, then that would allow you to then bring it up despite the court's ruling on the 609. But that may be something you're going to want to sidebar. And finally, how do you go about getting to this issue? Well, if the defendant is worried about it, they're going to have to file a motion to suppress the evidence. However, if there is concern about meeting any of the requirements, the foundational requirements, such as whether it's within 10 years, whether it qualifies as a crime and falsity misdemeanor, or if you're just worried about meeting that balancing test, a prosecutor should proactively seek a Rule 104 hearing on an evidentiary issue and make sure that that's fleshed out before you go in guns blazing to a trial. But absent that, if you're confident in meeting all of those, then make sure that you hold the defense accountable and put the onus on them to file a motion to suppress the evidence. And last of all, making sure that so that we can help our fellow AGs, make sure all the foundational requirements are met in each case, whether it be through stipulation or whether just putting it on a trial. Proffers are not going to cut it. It needs to be a stipulation by party, or it's going to need to be actually entered in as evidence, but make sure the foundational requirements are met, or you may have a problem on appeal. That's all I have. Rule 609 for prosecutors. Glad to be numbered among you.
Good afternoon. My name is Jake Summers. I am one of the prosecutors for Orem City. Being a child of the 80s and a child of two parents that were working full-time jobs, during the summers, I spent a lot of my summers watching daytime television, any sort of game show hosted by Chuck Woolery, The People's Court with Judge Wapner, and of course reruns of MASH and Perry Mason. Growing up, I always thought it was very interesting that Perry Mason always had that gotcha moment. In fact, Wikipedia has its own entry for Perry Mason moments themselves, and I found it interesting. It says, because of modern discovery requirements, Perry Mason moments are rare in actual American court proceedings. So the goal of this presentation is to give a review of Rule 16 and case law and refine our motion work as it relates to reverse discovery, with the ultimate goal to prevent any sort of last-minute surprise and enable us to make a full and thorough investigation of the merits of a defense theory. Also, it's to help us fulfill our Rule 3.8 obligation to seek justice and not just convictions. If we're able to not just preview a defense theory, but to actually investigate the merits of that defense theory, it will help seek justice and ultimately the right outcome in most of our cases. So Rule 16C provides us what defense counsel shall disclose to the prosecution. Some defense counsel believe that these are the only things they have to disclose, but Rule 16C says they shall disclose such information as required by statute. That includes alibi, insanity defense, entrapment, experts in general, and experts as it relates to mental state. As Marlise said earlier today, we're now going to have a new one, so it's a statutory requirement, the battered person mitigation defense. So that is going to be incorporated as a statutory disclosure. I'm going to run briefly through these each. Alibi, they must give you at least 10 days notice prior to trial. In that written notice, it must contain the location or specific information about the location of the defendant at the time of the crime, and names and addresses of witnesses that they anticipate calling to help establish that alibi. Really consider what the elements of your crime are. If you're talking about leaving the scene of an accident or even potentially DUI, where it's actual physical control and their claim is they weren't driving, does that provide an alibi defense? And do they need to give you that notice? So very consider each of the elements of your crime as to whether or not alibi is something that needs to be noticed up. Failure to notice up the alibi defense may result in the exclusion of that witness, but it does not preclude a defendant from still being able to testify as to that alibi information. Insanity defense, this is also codified in 7714.4. Not less than 30 days prior to trial, it must be written. What I found interesting about the insanity defense is the defendant must fully cooperate with the examination under 7716A301. Failure to do so will bar the defendant from being able to raise that defense at trial. Entrapment. Anybody who has done a vice crime in the justice court probably has had to defend an entrapment motion from the usual suspect as defense counsel. But it has to be written motion, has to be 10 days prior to trial, and you're going to have a hearing on that. That hearing is going to determine whether or not the defendant was entrapped. If the defendant was entrapped, the case will be dismissed. If not, it may allow the defendant to raise that defense at trial. Expert witnesses generally, this isn't going to be much help for the municipal prosecutors, but in general, defense counsel has to provide notice for any felony case that they anticipate calling an expert witness. That also includes for evidentiary hearings. Must be 30 days, at least 30 days prior to trial, at least 10 days prior to that evidentiary hearing. There are going to be content requirement of the notice, the name, address of the expert, the CV of the expert, a copy of the report, or at least something that puts you on notice of the summary of the expert's report and anticipated testimony. Failure to do so may result in a continuance. There could be other sanctions imposed. The expert's only going to be excluded if the court finds that the attorney acted deliberately to violate that statutory notice. For mental state expert witnesses, it's going to be, this applies to any trial or any hearing regardless of severity of offense, so felony or misdemeanor. Not less than 30 days prior to trial, not less than 10 days prior to hearing. Very similar content notice requirements. Here, the expert shall prepare a written report for you. If they fail to provide you a sufficient report, then there should be an accompanying summary of the anticipated testimony. Again, very similar remedies, a continuance, or other appropriate sanctions. Now, as I said, some counsel feel that that's the limit of defense disclosures, but there's more. Rule 16C provides the good cause discovery from the defense when the prosecution has good cause. State v. McInerney indicated that good cause means that that evidence is material to the issues that will be presented at trial. Materiality is just mainly relevance or significance. So there's not some sort of high bar here that we have to ask for something above and beyond. It's just, are there going to be issues pertaining to the evidence that we're asking that are material or significant to the anticipated trial or hearing? To help raise that, I think we need to really take a very proactive approach with our judges and even with defense counsel and provide an education paragraph or two in our motions for discovery. I've provided some quotations here. I'm not going to read them all. I meant to have that available just on the slideshow for you at home. But really, district courts have to manage discovery processes in a fair manner, something that doesn't give one side any sort of unfair prejudice. Also, discovery allows the court to ensure that there's a proper and prepared, effective cross-examination. Just as Crawford requires more than that the evidence is reliable, Crawford goes on to say that to ensure reliability, that evidence must be tested in the crucible of cross-examination. If we're unable to provide an effective cross, how can we ensure that the testimony is not incomplete, misleading, or deliberately fabricated. That concern is not just limited to the prosecution, but also to the court. The U.S. Supreme Court in Taylor v. Illinois went on to say, more is at stake than the possible prejudice to the prosecution. We are also concerned with the impact of this kind, failure to disclose information to the prosecution, on the integrity of the judicial process itself. Rules that provide for pretrial discovery of an opponent's witnesses serve the same high purpose and minimize the risk that a judgment will be predicated on incomplete, misleading, or deliberately fabricated testimony. So what should be in the content of our motion for discovery? Obviously, we need to state the basis for our discovery request, Rule 16C. Cite to our state precedent, McInerney, Spry, and Perea. Also, you can cite to U.S. Supreme Court, Taylor v. Illinois and Washington v. Texas. All of those cases have great language for us in getting a discovery from defense counsel. Clearly identify and enumerate the categories of the evidence that you're asking for: witness lists, exhibit lists, any sort of physical evidence that you anticipate that they may be presenting at trial. Establish the materiality to each of those items in your initial discovery request. Anticipate privileges and constitutional challenges that may be objected to or raised by defense counsel in your initial discovery request, and highlight your own compliance with their discovery requests. Prepare a proposed order that accompanies your motion for discovery. In that, ensure that there are findings that outline the materiality of the disclosures, the application of any privileges asserted by defense, and again, reaffirm the state or the city's compliance with disclosure requests. Put in a scheduling deadline or a scheduling order. That way you can hold the defense counsel's feet to the fire. It also allows you to be vigilant in making sure the defense responds timely to a request, and also ensures that the trial court doesn't need to do a last-minute continuance of this trial. Outline any sort of prospective remedies or sanctions for failure to comply with that discovery order. Often when I go to the CLEs, I think it always sounds easier than it actually is in practicality. So we need to be mindful of the objections that will be raised by defense counsel. One of the most common that you'll see is the right against self-incrimination. As we see that objection or that privilege raised, go through the analysis. To whom does that privilege protect? It protects the defendant. It doesn't protect the information. What type of information does it protect? It only protects against testimonial information. And further, it only protects against incriminating testimonial information. So if you're asking for witness lists or exhibits lists or evidence that they anticipate to present, is it incriminating? My guess is no. If they're anticipating to present it at trial, it's probably not going to be incriminating. Further, consider that self-incrimination privilege in light of 16H. 16H lists a litany of things that the city or the state can request the defendant do, like trying on clothes, be present for a lineup, submit to chemical tests. So in light of all of that, can it really legitimately be raised that a witness list or an exhibit list violates the self-incrimination privilege? Due process violation. This is really one that's raised where the state or the city hasn't provided discovery or is asking for a type of discovery that the state or the city themselves has not provided. It's really outlined in Wardius v. Oregon. You can read through that case, but we need to be mindful that discovery is a two-way road. We can't expect to get discovery if we ourselves aren't willing to provide discovery of the same category or nature to the defense. Work product privilege, again, I'm not going to go through all the tests for work product privilege, but really look at Utah Rule Civil Procedure 81, which outlines if there is not an applicable rule in the criminal code or the criminal rules, then civil rule provides a gap for those. Rule 26 provides for initial disclosures in civil cases. Those are going to really cover a lot of what we're asking for in discovery. So if it doesn't violate the work product privilege in the civil realm, does it really violate the work product privilege in the criminal realm? Also, work product can be waived. US v. Noble identifies that if a defense seeks to admit the testimony of the witness, he waives the privilege with respect to matters covering that witness's testimony. So if they're anticipating calling that witness at a trial, will a witness exhibit list or a witness list really violate their work product privilege? No, it will not, because the moment they elected to call that witness, that waives the work product privilege. Further, under Utah Rule of Evidence 510, if they voluntarily disclose that to you, then the work product privilege is also waived. How many times does that happen in our pre-trialing? Well, you know, witness so-and-so is going to tell you X, Y, and Z at a trial, so you really should take this action. If they're telling you that information in pre-trial, have they not already waived that information covering that witness's testimony? The most common is the attorney-client privilege. Again, go to the rule. Utah Rule 504B talks about what it protects. It protects confidential communications. It defines confidential communication as communication not intended to be disclosed to third persons. So if these are witnesses, summaries of witnesses' testimony that are going to be going before a judge or a jury, then it's not confidential because it's intended to be presented to another person, to that judge or to a jury. Ultimately, be vigilant. Get your scheduling order. Create reminders for you to follow up with defense counsel prior to that scheduling order's deadline. Send an email. Maintain those written records of your efforts. So when you get to that scheduling deadline and the defense counsel has not provided you discovery, you can file your notice of noncompliance under Rule 16G, and you can explain what efforts you took to be proactive to ensure timely disclosure. Remedies are available to us. Most often you're going to see a continuance. Under rare circumstances, you can get evidence excluded, but be careful. This may create an ineffective assistance of counsel claim. So you might win the battle, but you may ultimately lose the war by getting that exclusion. So be mindful of that. In closing, just again, the rule is here for us. We need to be mindful of it. We need to take the steps to be proactive and be vigilant in creating a way for us to give a full and thorough investigation of defense counsel's theories and claims. Thank you.
I'm happy to be talking to you today about House Bill 206, bill reform here in Utah. This is one of those bills that the legislature got right this year, and I'm sort of looking forward to seeing how this plays out. I think that the credit for this bill really goes to Representative Stephanie Pitcher. I'm a little biased in favor of Stephanie because Stephanie is a prosecutor in our office at Davis County. And she also helped me tremendously with this presentation today. But Stephanie worked really hard, and I think to hear her explanation for the things that went on with the legislature trying to get this bill passed, it's sort of interesting given the tremendous support that the bill had outside of the maybe party leadership, I guess, but she worked quite hard. This bill really is a culmination of several years of work by many individuals and different entities who all have different interests in the criminal justice system, but came together to really put something, I think, pretty good together. So this bill, as I mentioned, it was basically supported by everybody. SWAP supported the bill, the Judicial Council, the Bar, the Association of Criminal Defense Attorneys, the ACLU, very broad support. But like I said, the bill had some trouble getting out of committee and getting to the floor for a vote. So you would think that with this tremendous support, we wouldn't have that challenge, but the bill was not supported, as you can imagine, by the bail industry. And they've been fighting bail reform around the country and doing a lot of social media campaigning, at least here in Utah, while this was going on in the legislature, trying to spread some misinformation about the bill and to convince people that what this bill is a catch and release, that this is all about just letting bad guys go and will become, that bail reform is all about harming public safety. And one of the big issues that were brought up by the bail industry in fighting this bill was pointing to bail reform in Cook County and bail reform in New York, which has been controversial in both places. In February of 2020, Professor Cassell at the Utah Law School and an economics professor at the U published a paper related to the Cook County bail reform. The bail reform in Cook County was enacted in 2017, and 2 years later in 2019, the Chief Justice put out a report indicating that they had analyzed the data. They were showing that they were detaining far fewer pretrial defendants, and that crime had not increased as a result of that, and concluding that the bail reform in Cook County was a success. And Professor Cassell and Professor Foles from the University of Utah reanalyzed that data and came up with some different conclusions. And among other things, they concluded that there was a 33% increase in violent crime by pretrial defendants who had been released pursuant to the bail reform. The bail bonds industry took hold of this research and were presenting it to the legislature to try to convince the legislature that what Utah was doing is the same. New York, at the same time, in the last couple of years anyway, New York has also established bail reform that was very progressive and pretty much abolishing bail for all or most misdemeanants and a lot of the nonviolent felony offenders. In both Cook County and New York, there are also charities now that assist with posting bail too. So there's a tremendous amount of reduction in detention for pretrial defendants. So as part of trying to get the bill passed, Representative Pitcher was able to secure a letter from Professor Cassell, who indicated his support for House Bill 206 and explained the differences between what the Utah bill would be as opposed to Cook County and New York. And our bail reform is very different, and I think much better than what they came up with in those communities. As Marlise mentioned this morning, the effective date for this bill is October 1st of 2020, not May 1st. So it will be interesting to see come October where we're at with this. I think right now we're sort of engaging in one of the biggest bail reform experiments across the country with COVID-19, as we are doing a lot of releases. I know in Davis County, our jail is operating at about 1/3 of its capacity. So I'll be interested to see if someone is able to do some research to see what effect that's had on crime even before our new bail reform statute comes into play. Our bail statute 7721 will not change. There still is a right to bail unless the person is charged with a capital felony, a felony while on probation or parole, or while free on bail for a felony if the person poses a substantial danger or is likely to flee the jurisdiction. If they've charged with a felony and they've violated a material condition of release, and then if it's a domestic violence offense, which can be a misdemeanor domestic violence offense, and there's substantial danger to the alleged victim of a domestic violence offense. Of course, all of those are subject to a finding of substantial evidence to support the current charge. So that's all the same, and that's also mirrors the language in our Constitution, Article 1, Section 8. But now when a court issues a pretrial order, when a court has jurisdiction over a person who is charged or arrested, that court is directed to issue a pretrial order designating conditions to be imposed upon release. So this is different. So now a judge that's faced with a defendant at an initial appearance, it's not going to be, let's address bail. The question is going to be, let's address whether there are any conditions that should be imposed upon release of this individual. And the court who's trying to determine those conditions for pretrial release needs to impose the least restrictive, reasonably available conditions that the court determines are necessary to ensure the individual's appearance, the safety of any witnesses or victims, the safety of the public, and that the individual will not obstruct the criminal justice process. The courts have to issue those orders without unnecessary delay. The prosecutor can file a motion to detention, which we often do now, and if the prosecutor does file that motion, then the court should wait until a hearing if the motion states a reasonable case for detention and detaining the defendant until the hearing appears to be in the interest of justice and public safety. But the bill does obviously indicate a preference for OR releases, and the court shall order an own recognizance release unless it finds that other conditions are necessary to ensure compliance with subsection 3B, which are those conditions that I just stated in the earlier slide, that they are necessary to ensure the appearance of the individual, the safety of witnesses or victims, safety of the public, and that the defendant won't obstruct the criminal justice process. And I think that's one of the key parts of this bill, is that instead of just looking at arbitrary bail, now the court needs to really focus on, are these conditions really necessary to ensure public safety and to ensure appearance? So how does the court do that? Well, the court can look at several things. Number one is a pretrial services assessment, and this is something that Judge Cassell in his letter supporting the bill indicated can be problematic, and this is one of the problems that Cook County had, was that they were relying on a pretrial services assessment that really was broken. And we're using these in our jurisdiction. I think most of the state now, there's a tool that the courts are using to kind of use data really to determine the risk level of an offender who's arrested. And I think that those tools are really helpful and that the court needs to use them, but I think we also need to use caution, because sometimes there is a lot of information that's not part of that process of putting together that assessment. The court can look at these other factors about specifically, and this is a really individualized determination for the court. So they really need to look specifically at the offense, the individual, potential dangers, whether the person was on probation, parole or pretrial release, whether the person has support of family or someone in the community who can help the defendant to comply with the terms of a pretrial release, and then their willingness to participate in some kind of program that may be a condition for the release. The statute lists out a number of conditions, and these look a lot like conditions that judges might impose when a person is placed on probation. And I think that's where this is going to be key, because as we can continue to develop our pretrial services agencies to operate almost like probation agencies, I mean, I think that's a little ways coming with the funding, but that I think we can have more success with pretrial release and ensuring that defendants comply with court orders. Other conditions are listed here. One of the conditions that the courts can use is that the defendant comply with a financial condition, and that's bail. So bail is still a part of our system, and courts can use bail to ensure a defendant's appearance in court. When a judge does impose a financial condition as a condition of release, the court has to consider the individual's ability to pay when determining the amount of financial conditions. So no more will judges just be saying this is a Class A misdemeanor, bail is $2,500, third-degree felony, bail is $5,000. Now judges are to look at the individual defendant, consider all of the needs of the defendant and the public safety issues, and then also look at a defendant's ability to pay when determining an amount for the bail. There is a rebuttable presumption that individuals who are charged with homicide or first-degree felonies, that they will be detained. I think that's a good change to the law too, because it's for those of us who have been to court with defendants who have been charged with things like aggravated kidnapping and rape, who are wandering around the courthouse because they have enough money to post bail. It's concerning, and these are the people who really ought to probably most times be detained. The court has to issue a pretrial status order when the court issues a warrant for arrest. And that's one thing that I think is going to be tricky for the courts. So I think the more information we can provide in our in the requests for warrants when we're filing informations for charges and we want individuals detained to help the courts do this will be probably one of the most important things that we do in cases where we want individuals to be detained. Marlise went over some of these changes to the bond forfeiture statute, and she talked about how when we're enforcing those bonds and when individuals don't appear for court, 15% of the forfeited bonds will come directly back to the prosecuting agency that collected the bond, but also 60% of the bond will go to the CCJJ to fund grant programs to help fund pretrial services agencies around the state. So it really is important for prosecutors to start or maybe improve on how they're enforcing those bonds and collecting the bonds. And like I said, the funding for pretrial release programs will come from a lot from the money that's collected from the bail forfeitures. All right, thank you for your attention. And,
Thank you, Susan, and Blair, and Jake, and Ivy. And thanks to everybody who's helped put on Spring Conference. Again, our thanks to Steve Garside, Layton City, Gary Crane. I appreciate you guys hosting us here. And Bill from the Imagination Company. I've been getting some reports from you guys that technically things have gone well on his end, so we appreciate that. Don't forget, fill out your valuations. A couple weeks to get that done, and hopefully, we're looking forward to seeing everybody next year at the Sheraton. All right, you guys have a great day.